Hey guys, welcome back to my channel. Welcome back to Real Talk Bougie. Guys, we are on the record. This is the tail end of Sarah Boone's jury selection. Let's get into it and I'll see you at the end.
Selection process that began on Monday. You've been seated at counsel's table either here in 23 Alpha or 12 Alpha of the Orange County Courthouse, and you've been able to observe the jurors during that entire process. Were you able to hear the questions asked of the jurors and their responses?
Yes.
Did you confer with your counsel about who you wanted or did not want to be selected for your jury?
I did.
Do you believe you were given a meaningful opportunity to participate?
Yes.
Is there anyone that you wanted to keep that your lawyers struck?
No.
Are you satisfied with your attorney's performances so far in this trial?
Absolutely.
Do you agree with the panel that has been selected for your case?
Absolutely.
Is there anything you would like to bring to my attention at this time?
No, thank you very much.
When the court reads the 2.1 preliminary instruction, defense, would you like me to read the defendant's right to remain silent section of same to our panel?
Yes, Your Honor.
All right, thank you very much. Bring our panel in. State.
No, Your Honor.
Defense.
No, Your Honor.
Okay. Let's go ahead and bring back in our panel. We will stand. Madam Clerk will identify them by their badge number. I will ask them to remain seated where they are, and then we'll excuse the balance of the panel. I will give them an instruction. Court will then read the 2.1 instruction and 2.1a note-taking instruction and provide explanation for where we will be tomorrow morning. So let's go ahead and stand and bring in our panel. Do you have a blue pen? I only have black. Thank you.
Thank you.
Jury will already have their certificates ready downstairs and send them back to them.
Good. Thank you. State, do you recognize our panel?
Yes, sir.
Defense, do you recognize our panel?
Yes, Your Honor.
I thank you. All can be seated. Members of our panel, we have been able to select a jury to serve in this case. Madam Clerk is going to call you out by your badge number, not the paddle number that you've been using all yesterday and today. Please stay in your seats when your badge number is called. Madam Clerk?
Juror number 295. Juror number, you want them to stand? So.
Please, if you could stand when your name is, your badge number is called, please. Thank you.
Juror number 9, remain standing. Juror number 569. Juror number 515. Juror number 130. Juror number 249. 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. And juror number 102.
State, do you recognize the jury is selected?
Yes, Your Honor.
Defense, do you recognize the jury is selected? Bless you.
Yes, I do, Your Honor.
All right. Thank you. You all can be seated. Thank you very much. To the members of our panel that were not selected, I thank you so much for your time and your participation and your attention in this very important process. You have my thanks, the thanks of the lawyers, and the thanks of Ms. Boone. It is entirely up to you whether or not you would like to discuss this case. You may do so, or you may decline. That privilege is yours. Please proceed now back to the jury assembly room, where they will validate your parking, provide you your jury certificates, and give you further directions. Thank you, God bless you, and have a great rest of the week. Please don't go anywhere. Mary, do roll call one more time. Okay. Please.
I'm just going to do a roll call.
Y'all can be seated. Thank you.
Just going to do a roll call. You don't have to stand, just raise your hand. Juror number 295. Juror number 9. Juror number 569. Juror number 515. Juror number 130. Juror number 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. Juror number 102.
All right, thank you. All right, members of our jury, I have a couple of instructions to read to you. Oh, yes, Madam Clerk needs to swear you in. So if you could please stand up, raise your hands, please.
Do you swear or affirm to truly try the issues between the state of Florida and the defense and render a true verdict according to the law and evidence, so help you God?
Thank you all very much. You can be seated. Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of the state of Florida versus Sarah Boone. This is a criminal case. Ms. Boone is charged with murder. The definition of the crime charged will be explained to you later. The state's charging document, which is called an information, is not evidence, and it is not to be considered by you as proof of any guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Ms. Boone in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, Witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. End of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. The contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, The trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result, which would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted as so to consume as little of your time as necessary for a fair and orderly trial of the case. Members of our jury have one additional instruction to read to you regarding note-taking. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. With that, members of the jury, we will pick up tomorrow morning in courtroom 12A of the Orange County Courthouse, and we will begin with opening statements at that time. I instruct you to follow the instructions that I've just read to you, including not reading any newspapers or watching the local news, having any conversations with anyone, or conducting any independent research or investigation as to the persons, places, things, and charge in this case. With that, again, I thank you for your service, and we will see you in 12 Alpha tomorrow morning at 9 a.m. May the parties approach for one moment. Mr. Owens, once you've had that conversation with her, just let me know.
I may. I've conferred with my client about the issue on cross-examination of her ex-husband, Brian Boone, about the family law case, the dissolution of marriage case. And through my cross, if I explore those issues, it may come out that she's been in jail pending her arrest back in February the 24th of 2020, so 4.5 years. She understands that may open the door. It may come out. She understands that I have to make a decision about whether to explore that area of cross-examination, but I believe she's going to say that she trusts my judgment. She is concerned about it coming out that she's had 8 prior attorneys. She does not want that coming out, but that's her biggest concern.
Okay, we'll address that in just a moment. Ma'am, I don't want to go into the specifics of any conversation that you've had with any of your attorneys on that issue. I just need to know whether or not you've had those conversations, okay? Is what your lawyer just represented accurate as the conversation that you've had as to that issue regarding cross-examining your former husband, Brian Boone?
Yes.
Okay. Do you understand the risks that if he seeks to impeach or call into question the bias and credibility of your former husband, Mr. Boone, as to what has transpired in your dissolution of marriage case, it may open the door to the fact that you have been incarcerated since February of 2020?
Yes.
Are you in agreement with that strategy, understanding those risks?
I am.
Okay. Now, with regard to your concern, ma'am, over having 8 prior attorneys, I don't intend on allowing it. I'm sure that's not part of the state's case in chief.
No, Your Honor, I don't see how it would possibly become relevant, but if we somehow believed it did, we would certainly have a sidebar before anything about that.
If by some circumstance that somehow becomes relevant, I'm going to ask the state to approach before we even get near addressing that issue in front of our jury. Okay? Ma'am, do you have any other questions for me at this time?
I do not.
All right. State, anything further?
No, sir.
Defense, anything further?
No, sir.
All right, we will see you all tomorrow morning at 9 a.m. The court will conduct its regular docket.
Okay,
8:30.
guys, there
Thank
you have it. Today
We're off the
is
record.
Thursday, October 17th. I feel like we have been through it. I mean, earlier today, the hearing, then after lunch, going into jury selection. I just happened to catch the end of this on a feed coming directly from the court. So this was pretty interesting. I feel like I captured the most interesting part, but let me know down below if you would like to see this in its entirety. I feel like today, gosh, I'd have to get the total hours, but I think we'd probably be looking like 4 to 6 hours, something like that. Maybe four-ish, something like that. But anyway, the most important things, the jury has been paneled. They have alternates. They seem ready to go. I found the questions very engaging and thoughtful. So let's look at this. Comment down below. Let me know. But maybe Saturday, something like that. We can watch this because we've kind of seen everything else. So if you want to catch the jury selection, we can do kind of review and hear the prosecution, the defense, how they picked their jury selections, the questioning. I did hear Mr. Henderson's portion. It was pretty interesting. Anyway, this right here never gets old for me, seeing Sarah taken into custody, back into the custody of the Orange County Sheriff's Office jail, and her the sheriff's deputy who is assigned to Sarah to make sure that she gets from A to B safely and securely. So yeah, Sarah has been rocking this gray suit. She's had a couple of different tops to go with it. I guess that was Tuesday, Wednesday, today. Monday, she had on her outfit that kind of looked like her blue jail uniform. Anyway, this is not a great position to be in. She is definitely fighting for her life, but she definitely seems to be rolling straight through the process, somewhat even kind of enjoying. She smiled a lot during jury selection. I don't know if that was under the advice of her counsel, but look, hey, interesting process. If you enjoy content like this, make sure to subscribe, set your notifications, and I'll see you guys next time. Bye.